Most of us have heard the term restraining order, but what does it really mean? What's involved in getting a restraining order? Do you have to meet certain criteria to file one? What protections are in place once a restraining order is filed? This is Unsilenced, a JBWS podcast where we have real conversations about abuse. I'm MC Robinson, and today I'm speaking with two attorneys, Alexis Laufer and William Laufer. I'm also speaking with Maria Lagatuda, the director of our Morris Family Justice Center, and we're going to talk all about restraining orders. We cover the difference between a temporary and final restraining order. We're going to explore the process of seeking a restraining order and detail the difference between civil restraints and restraining orders, as well as just answering a bunch of frequently asked questions about restraining orders. Just a few notes before we get into this episode. This discussion predominantly refers to obtaining restraining orders specifically in New Jersey, so some laws may be different if you live in another country or another state. And unfortunately, the process of filing a restraining order can feel challenging. The burden of proof lies with the victim, meaning they have to prove a need for seeking the restraining order. That can sometimes feel punishing to someone that's experiencing abuse. Throughout this episode, we speak plainly about restraining orders within the context of the court and the legal system. But it's important to remember that choosing a restraining order is entirely up to the person experiencing abuse. They are the expert in their experiences and in what they need. There's also some gendered language in this episode, but just to be clear that people of all genders and sexual orientations can experience abuse and can seek restraining orders. If you need support, please do not hesitate to reach out to your domestic violence agency or to call JBWS if you live in Morris County, New Jersey. Our resources are linked in the show notes and at the end of this episode. Now, before you listen, please take a moment to subscribe to Unsilenced wherever you get your podcasts, because it helps us to break the silence around domestic violence. So today we're talking about restraining orders. And in order to really talk about that, I think an important first step is to just identify what is a restraining order.
So it's basically a protective order, and it's issued by the court to protect the person in a situation often involving alleged domestic violence, child abuse, neglect, assault, harassment, stalking, sexual assault, all of those issues. You basically have the burden of showing to the court that there was irreparable harm that will occur to you or your children, and they will suffer irreparable harm unless the judge orders immediate, substantial relief. So the irreparable harm will occur unless a protective order is submitted. But in order to get a restraining order, you have to be eligible under our statute to get that. In other words, you have to be married, divorced, separated, dating, have a child in common, living together as roommates or parents living in a house. These are the people that qualify to be able to go into a courtroom and obtain a restraining order against a certain individual.
Mm.
Okay, and as a result of that, the judge can enter orders. They can order sole custody to a party. They can enter an order for no contact. In other words, the violator can have no contact with the person seeking a restraining order. They can order them to vacate the marital home, and they can't come to the home or even on that property. They can limit or suspend their parenting time with children if they're involved. They can also order temporary financial support under certain temporary or final restraining orders. So that's kind of the definition of the quote restraining orders that we're going to be talking about.
As we move into this, I do think there's a lot of questions that people have because this isn't really well known. So we talk about the difference between a temporary restraining order and a final restraining order. So what is the difference there and what does that kind of look like?
Okay, so we call it a TRO, which is a temporary restraining order, and then an FRO, which is a final restraining order. A temporary restraining order is exactly what it says. It's a temporary order that is granted Many times it's called ex parte, where, for example, if you're concerned that if your spouse who is violating you is going to do something different, if he's aware of the fact that you're going to get a temporary restraining order, that could hurt. So a lot of times it's ex parte. In other words, you make an application to the court without even advising the other party that you're doing that. It could be with notice or without notice. And therefore, a court will listen to what you have to say. And if you can show the court that there's a predicate act that rises to the level of the domestic violence, which I've kind of defined before, the judge will enter an order, but he will give the perpetrator the right to challenge that order. And usually within 3 to 5 days, the judge will down a hearing date. So the perpetrator has the right to come back to court and say, that's not true. I didn't do that. It's wrong, whatever. And therefore, I want the temporary restraining order dismissed. So you have a trial. Both parties will testify. They can bring in witnesses if they want to. And the testimony basically will be in front of a judge. It's not a jury. The judge will hear the testimony of both parties. You can bring witnesses if you want to. And as a result of that hearing, the judge will make a decision whether or not you've met the burden of turning that temporary restraining order into a final restraining order. They can also dismiss the temporary restraining order if it hasn't risen to the level of showing the domestic violence that we've already talked about, the
Mhm.
irreparable and immediate harm to that person. So you need to be prepared when you go in there. We'll talk about that later. So the TRO will become a FRO, a final restraining order. So these restraints that this judge has ordered temporarily, whether putting the husband out of the marital home, or whether he's limiting his rights to visit with the children, or whether he's ordering supervised parenting time because there's issues, etc., they now become permanent. So it becomes permanent restraints, and they are pretty intense. When they're permanent, they're pretty much locked in. So that's the difference between a TRO and an FRO. All
Mhm.
right, basically turning a temporary into a final. But before you get to the final, the other party has a right to come in and present their case as to why the final restraining order should not be entered. So when you go to a hearing for that final restraining order, you need to be prepared. Have a trial before a court. You'll take the witness stand. Put your hand on the Bible. You give your oath, and you will tell your story. And if there's other people that you want to come in to supplement, whether it's a therapist or a doctor or police department or police records, all that can be introduced at the time of a hearing so the judge has enough information in front of him or her to enter into a final restraining order.
I do want to just jump in here too, that the burden of the proof lays with the person who obtained the restraining order. So unlike what you see on TV, you see the jury box. This is not a trial by jury. The judge is the one who makes the decision, and the burden of proof lays on the person who got the restraining order, not the defendant.
Correct. The burden of proof is on the person bringing it before the court. Again, showing that irreparable and immediate harm that will occur.
Couple of things that I feel like a non-court person might wonder. Predicate Act. What does that really mean?
The predicate act is the act of which you are now claiming. My husband came into the house. He took a bottle and he threw it at me and it hit me in the chest and I went down and I was injured. That's the predicate act. It
Mhm.
could be my husband, and I'm using this as an example. My husband calls me on the phone every day, 10 times a day, threatening me, accusing me. Those could be the predicate acts. Now, the predicate acts are basically what a court will hang their hat on. But the predicate acts don't have to be as intense as throwing that bottle at somebody and hitting them. It could be a repeated scenario of actions that lead up to the point where that person has been so abused over a period of time that the final straw that breaks the camel's back is that final phone call. I'm coming to the house and I'm going to kill you.
Mhm.
Okay. That could be the predicate act. Now, that in and of itself, it's the first time that ever occurred, may not carry the day. But if you can show a past history, and that's very important. The prior acts of domestic violence, whether you brought them to the court or not, are very relevant. You could show a string of things that he's done. He's threatened me 10 times, and 9 of those 10 times, he's actually come to my house and he's abused me. This is the 10th time. And he never came to the house, but I'm so scared that that would be my predicate act, predeceased by those prior acts. So the predicate act is the act which a court will find that is domestic violence.
Okay. So a predicate act then doesn't always need to be physical. The other thing I will ask, Maria mentioned a burden of proof. Do you want to explain what that means? Like, what does the burden of proof being with the victim mean?
With the burden of proof, so you need to prove number one, that the predicate act occurred
Okay.
and that you are in need of a restraining order in order to be protected. So
Mhm.
there has to be a need for the restraining order. And the judge, that's why testimony is taken. It's very heavily weighted on not only evidence, but testimony, credibility. So, if you have somebody in there who doesn't seem to care and they're testifying and, they may not be seen as extremely credible, or, we always tell our clients, it's okay if you cry. Like, don't hold it back. Show your emotions in these cases because you want everybody to understand that you need this. You need the protection of the court. You need the protection of the restraint, the final restraining order, because that's the goal,
Mhm.
right? If that's your goal. Yeah, you have to prove that the predicate act, which there are 19 different criminal offenses that qualify as predicate acts, actually happened. And taken in conjunction with that prior history of domestic violence, taking into account everything that has occurred in this relationship, whatever it may be, right? Dating, married, divorced, living together, that you are in need of protection based on looking upon all the facts.
In a criminal action, like if you have a jury trial of someone's crime, you have to show beyond a reasonable doubt that it occurred.
Mhm.
All right. In a civil action like this, you don't have to say beyond a reasonable. It's basically more likely than not that it occurred. Okay. The preponderance of the evidence, we call it, leads to the fact that that did occur. It doesn't have to be like 12 jurors, all 12 have to say yes. Maybe it's 7 out of 12, beyond a reasonable doubt versus a preponderance of the evidence.
Great. I really appreciate you guys really breaking it down because I think it can be kind of overwhelming if you're not involved in the court system. But just to kind of keep in this vein, what is really involved in obtaining a restraining order? What do you think victims of domestic violence need to know when they're thinking about filing for a restraining order?
A lot of times people aren't sure if they should go. What we tend to see here is that people will not get a restraining order when there's something physical that happens, um, for a ton of different reasons. Hope that their partner is going to get better. This is the first time it happened. It won't happen again. They promise to change. But then what happens is people won't get the restraining order at that time where it's physical and there's a stronger, what we call a stronger predicate act. But then the name calling happens. And then one day they're just like, I'm done with the name calling. And then their predicate act isn't as strong.
Hmm.
Oh, the physical violence was a year ago. Why do you think you need a restraining order now? Which is unfortunately what happens with a lot of our cases. So I think if people aren't sure, if they're on the fence, having a conversation with a legal advocate or someone, because then they can at least have information.
Mhm.
They don't have to do anything. We're going to let them lead, but at least they have information to decide what they want to do.
On that note, timing becomes relevant because if someone does something to you and you're going to go into a courtroom and say, Judge, I'm scared to death. It's irreparable harm. You need to enter an order right now. I'm scared for myself or my children. And you don't file that for a week later.
Mhm.
Okay. The
Right.
judge is concerned. If you're so scared and you're so concerned, why did you wait a week later? And by the way, what did you do during that week? Did you live in the same house with him? Did
And
you?
it doesn't even have to be a week. It could be you could say, well, the predicate act is this morning he said, I'm going to kill you. And then I went to work, and then I came home and I had dinner with him. And then I went to bed. And then the next day I woke up and I went to the police and I asked for a restraining order. Something typically occurs and then it takes more and more and more for them to finally have had enough. But sometimes, as Billy said, the timing isn't correct. So I know the advice we give our clients is if you are scared and you want a restraining order, you need to be ready. You need to be prepared. This doesn't come out of the blue in most cases. This is usually a series, a history of domestic violence that leads up to something. If something hits hard and you know this is it, I can get it now, you go and get it. Because what you don't want is to file a get a temporary restraining order, go to trial, and have it dismissed. Because now that perpetrator can move back into your house. There's nothing preventing them from doing it. And then it can happen again. And it could happen worse the next time because now they're angry that you did this to them. I think it's also important to know, going back to what's involved in obtaining a restraining order, how you get the restraining order. You know, what do you do?
Yes.
So if this is very specific, Monday through Friday from 8:30 a.m. until 4:30 p.m., you can call the police, right? If somebody's assaulting you in your house, you're going to call the police. The police will come out and they will say to you, do you want a temporary restraining order? And if you say yes, during those hours of the day, Monday through Friday, 8:30 to 4:30, they will tell you, you have to go to the courthouse and get it. We can't give it to you. So sometimes cops will drive the victim to the courthouse also. And bring you there and make sure you get there safely. If it is after the hour of 4:30 or before 8:30 in the morning, Monday through Friday, or on a Saturday or Sunday, in other words, if the court's not open, okay, even if it's a court holiday, you can't get the restraining order from the court, the police have to offer it to you on the spot. So if they come to your house for the 911, you call 911 first, all right? They come out, they investigate. And then they will say, do you want a restraining order? And you say yes, and it's outside those court hours. They will drive you down to the station or say, meet us at the station. And it's important to know, if you have children at home and you want those children to be protected parties, you do not leave them home with the soon-to-be defendant. You bring those kids with you. Because if you want the kids to be protected, same thing as coming home and having dinner with the defendant. You don't want to leave your kids alone with the defendant while you're going to file the TRO. That happens a lot, and it doesn't look good when the judge says, well, then if you're so scared for the kids' safety, why did you leave them home when you went to the police station, right? So bring the kids to a neighbor's house, bring the kids to a friend's house, your parents, somebody that you trust, and then go, or bring them. You're gonna have to bring them with you. But you'll go down, the police will put you on the phone with an on-call judge, and you will, over the phone, tell the judge your story. And the judge will ask you what happened. It's pretty easy to get a TRO, by the way. Pretty easy, because the judge on the other side of the phone, picture it being midnight or 1 a.m. This judge is sleeping, picking up the phone and listening to you and saying, okay, if I don't give the TRO and this victim goes home to the potential, perpetrator, and God forbid something happens, the next day in the news, my name's going to be in the news, the judge who denied the restraining order and she went home and got killed, right? So it's very easy to get. Judges, especially the, municipal or on-call judge, will typically grant the restraining order unless it's so outlandish that it doesn't rise to the level, and then leave it to the superior court judge when you go for the final restraining order to make that final decision after having a trial. So that's how you do it. You call 911, police come, or if it's not an immediate incident, you drive to the courthouse or you drive to the police station and you report what happened.
Yeah, and you mentioned there's different reasons that people might seek a restraining order, but could you just give some concrete examples? Like, I think some people, to your point, right, think, okay, I don't know if that rises to the level of which I should seek a restraining order from this. So, like, are there certain things or concrete examples that you could give that somebody could get a restraining order for?
Sure. So as I said, there's 19 different offenses, or they call them criminal offenses or predicate acts, that are listed in the restraining order statute. Some of the most common we see are terroristic threats, harassment, assault, false imprisonment, and more lately, cyber harassment.
Also strangulation. We're seeing more and more strangulation and people getting restraining orders just based on that.
Yeah, physical assault,
Yeah.
sexual assaults, All of those rise to the level. Those are the easy ones to get. But yeah, there's a plethora. And like Alexis said, we find the judges today more than ever are deciding on the side of caution. They are granting the TROs. They don't want to take a chance. There's nothing to lose, no downside for them to enter an order with a TR with a temporary restraint. Then they leave it up to the superior court judge to have a hearing to determine whether or not it becomes final.
Hmm.
Right. And some examples, right? So terroristic threats, okay? I'm going to kill you. That's a terroristic threat. If you leave me, I'm going to come after you and you're going to regret it.
Hmm.
That's a threat. Some examples of harassment. So harassment's very specific. There's a specific definition for it, but it's very broad in terms of what can be under that definition. So harassment is conduct intended to cause alarm, serious annoyance, including offensive communication, physical contact, and that can be shoving, kicking, striking. Now, those might also fall under assault if there's bodily injury as well. But if you push somebody and there's no bodily injury, it could be constituted as harassment or any other alarming conduct. So harassment, somebody calls you 50 times in a row at midnight. That's harassment. Sends you text messages saying, vulgarities, on and on and on in text messages, and sometimes this occurs in a scenario where there's been cheating, right? So the victim actually cheated on the defendant, and the defendant has the right to be mad, right? So if 3 text messages are sent saying, I just found out you cheated on me, you're a whore, right? That might not constitute harassment, but if it keeps going, right? The repeated conduct, the repeated alarming, inconvenient hours, offensive language, repeated acts intended to alarm or seriously annoy somebody, that is harassment. So 3 angry texts because you found out somebody's cheating, fine. 100 angry texts, not fine, right? So there's a balancing act here. But again, it's general in the sense that the repetitiveness of it can constitute the harassment. Yeah. So I mean, as I said, assault, that's obvious. I think people understand, punching, kicking, causing bodily injury to somebody. False imprisonment, people might not know what that is. And this happens a lot, by the way. So that is when you're knowingly restraining another person in a way that interferes with their liberty. This means intentionally confining somebody against their will, preventing them from leaving, preventing them from moving freely. For example, blocking a doorway. We see this all the time. Taking their car keys, locking somebody in a room. Somebody wants to leave. I want to leave. You're scaring me. Take your car keys and I'm going to stand in front of the door and I'm bigger than you. That's false imprisonment. So that is a predicate act as well. And again, the list goes on, but those are kind of some of the bigger ones that we typically see.
I think it's really helpful to break it down like this because I don't think people know what they can really seek this for. So I appreciate that. When we talked about this episode, we discussed briefly maybe the difference between a civil restraint and a full-on restraining order. So why would a person choose a civil restraint instead of a restraining order?
The good thing about a restraining order, if you want to enforce a restraining order, I'm going to use the man-woman scenario. The husband violates the restraining order. The wife can call up the police and have him arrested for violating the restraining order. That's a criminal offense. They will arrest him. They can throw him in jail. They don't have to go into a courtroom. He violated the restraining order. Civil restraints can be negotiated. You can negotiate what you're going to do. Okay, you can see the kids every other weekend and supervise. You can't come to the marital home. You pick the kids up outside in the driveway. You can't come in. You can negotiate a deal. It now becomes a court order in the divorce action. It's a civil court order setting forth civil restraints. If the husband violates those civil restraints as opposed to the restraining order, it's not a criminal offense. The wife would have to go back into the courtroom and say, Judge, he violated the civil restraining order. Sanctions, they can be imposed upon him. but it's not a criminal act, which means that normally it will not lead to something like losing his job or being incarcerated. So that's the big difference between civil restraints and a restraining order, in my opinion, are the enforcement that I've just talked about and in regard to whether they're violated.
We have found when someone does enter into a civil restraint and the partner is not following it, there isn't the enforcement and things can escalate.
If there is a very serious act of domestic violence, and there is no question that this person is a loose cannon, the defendant, and they will come after you and you're afraid. If you are afraid, you get that final restraining order. You seek it, you go after it.
And you're right.
Right?
And the other thing they can do, which is another thing for a restraining order, which are very important, all weapons get confiscated.
Yes, in a
And
final,
that's
but
very,
not in the civil.
And again, we know that we are going to let the survivor make their decision. They're going to be the ones who decide this, but we're going to say these are your options.
And we're explaining to everyone now, we say, here's the difference, right? Repercussions are criminal, arrest, jail, and now they're going to be afraid because they don't want to lose their job or they don't want to get thrown in jail. Now you have them, the defendant, in a place where they're going to respect that order much more than they would a civil restraint order. When you have a serious abuse situation and a survivor needs that protection, getting that final restraining order is the way to prohibit additional abuse. And if they do it again, if they show up at your door and you have a final restraining order, all you need to do is call the police and they will be arrested and transported away from you.
and on a civil restraint, you can also put in there that the parties hereby agree to go to to go to counseling or therapy with their kids or without their kids. And these are things you can do in civil restraints. You can't do that if you have an FRO because you have a no contact provision. So there's things that we move on to try to, maybe they're going to reconcile, who knows? Final restraining orders don't lead themselves to reconciliation.
If you could give victims of domestic violence that are seeking a restraining order some advice, what would it be?
First of all, you need to tell them that it's imperative that they have to convince this judge that there will be irreparable harm will befall to you and your children, judge, if you do not grant this final restraining order. Be prepared to discuss prior acts of domestic violence, whether you think they are domestic violence or not. Tell a story about what's happened over the last 6 months or a year that led you to this point where you're now so concerned that if you don't grant this, judge, irreparable harm is going to come to me. And I hate to put it on your shoulders, but if you don't grant it and something happens to me, judge, just like Alexis says, you'll be front page of the newspaper because this is serious. They have to show the harm. They have to show the threat of harm. They have to show that they're scared for their safety and the well-being of their children. And again, you need to focus on this predicate act. Make sure it rises to the level of a predicate act. Harm, threat of harm, those type of things. Be prepared to also have available photographs that you have, emails that you have, doctor's reports that you may have, therapy reports, emails, all these things that will advance your claim, to basically come to the level of convincing this judge that this is all happening to me. And on that, Alexis, I'll pass that on to you now.
I mean, advice in seeking the restraining order is if you are afraid and you want protection and you need protection, it's available to you. If you know something's not right, if something's being done to you that is not right, you know it in your heart. And even if you've been so broken down and abused, don't be afraid. There are people out there who can help you, right? There's JBWS. There are attorneys. There are people who are volunteering their time at the court. There are ways out of your situation. And if you get that restraining order, and if you get that separation, that court-ordered separation from your abuser, you can move on and live in peace. You have boundaries that are set in stone for you. You will feel more free. You will not have that person living in your home, calling you, harassing you on text messages, trying to control you. There'll be limitations on contact. You get an FRO, you have the protection of the law. If they violate it, they get arrested. They can be put in jail. And we talked about this, they will have all of their weapons removed. Their guns will be removed. So if you are afraid that somebody you are with has a gun and is going to hurt you and is threatening you verbally, preventing you from leaving the house, physically assaulting you, and you are afraid that they have these guns, and something they do rises to the level of domestic violence, becomes that predicate act, you go to the police. You go into the court. You tell your story, because then you can live in peace and you're not going to be looking over your shoulder everywhere you go, wondering, is this person going to come get me?
Maria, I'm sure people come to see you in a situation where, correct me if I'm wrong, that I'll bet you every person that comes to see you should have been there before. Should have been there before. The title to my book, when I finish reading, is going to be No One Gets Divorced When They Should. I've been doing this for a long time, and probably no one who goes for TRO, everybody should have done it before. It's human nature. People are afraid to do that. They're concerned that they're going to be denied. They're concerned that it's going to empower the other person if it's denied.
But we also, coming into it from the social worky piece, people stay for lots of reasons, because of their kids, because of financial stuff, because they truly loved the person when they first got together. And maybe if I stay, maybe things will get better. So there's also that social emotional piece.
100%.
A lot of people won't, because of family of origin, cultural reasons, religious reasons. We don't believe in divorce. We don't believe in separation. So we are also helping hold some of that space for folks when they come in, when they're not sure what they want to do. There is no right or wrong. It's complicated, whether they go for it or they don't. It is really complicated.
Yeah, I know.
And I have to say, it doesn't matter how much money you have. We do get a lot of high income clients at our law firm. Every scenario you just referenced exists no matter how much money you have.
Exactly.
Family of origin, religious beliefs, don't want to uproot the kids. It's so hidden by everybody because they live in some kind of affluent community where they don't want it to be known.
We all agree. Basically, I can't agree with you more. I don't think I've ever had anyone come into my office to get a divorce that should not have been there a year ago, 2 years ago, 10 years ago, 3 months ago. Never. And you're right. It's human nature. For all those reasons you just talked about. The kids are going to graduate from college. We want to stay in the house. I'm okay that he goes and fools around. I'm fine with the way things are at the marital home. He pays all the bills. There's a million different and that's human nature. You have the same thing. Tough.
And just to make one last comment, it does also seem like things aren't really set up from a victim lens, right? Because to your point, Alexis, well, why would she go home and have dinner with him if he threatened her life? But a lot of times that's like fundamentally misunderstanding domestic violence.
Right.
I think that's tricky too, is that yeah, it's a fair question, but it's also like maybe she felt she couldn't. And then how do you allow for that nuance in a restraining order? It might not be possible.
And there's ways that the person can testify at trial about why they did it. I'm not saying just because you did go home, don't bother going and getting your restraining order, right? It'll just be something you'll have to explain. I was afraid that if I didn't go home, I didn't know what I was going to do with our kids, like how to get them out safe, or it would make him think I was going to, go and try and get this restraining order against him. So he'd be suspicious. And, you can explain yourself. So don't be afraid to get it just because you did go home after, right? I don't want that comment that I made to scare people into not getting it at that time. Go get it. Go try for it. Like I said, TRO is really easy to get. It's not a high burden, okay? And it's only your story. The defendant is not there explaining.
You can explain to a judge why you didn't do it before, and there's valid reasons. A lot of what we're talking about. 100%.
I think this has been really, really insightful. So before we wrap this up, is there anything else you guys want to add or a message that you want to make sure we get across?
The prior acts of domestic violence, I think, are very important, and that victims should know that when they go to apply for a temporary restraining order, you're under a lot of stress at the moment, so you might forget to put in these prior acts. You know, and the cop will say, has there been a history of domestic violence? Or the judge will ask you, and you'll say, yeah, you know, he's put his hands on me before and you know threatened me before, but then you go home and you have this restraining order in your hands now, right? The defendant gets served, removed from the house, and you have a court date coming up the next week, and you say, oh my gosh, I forgot to include all these other things that now that I'm home and I'm calm I can think about. You go back to the courthouse and you amend your temporary restraining order
Great
to
point.
include as much detail as you can. Actually, let me take that back. You don't want as much detail. You want to put general, you know, January 2023, defendant strangled me. Okay. Now that you put it in there, you can testify about it when you go to trial. If you do not put it into, if you don't add that to your TRO, you cannot testify about it at trial. You have to put it into your TRO. So go back, add to it. If you're in a situation today where you are being abused on a daily basis, that harassment is going on a daily basis, get an app, get a secret app on your phone, start making notes. Save a hidden album on your phone of pictures of bruises. Have it ready to go for that one day when you know that Predicate Act is going to come and you're going to have enough strength to do it, so you can go in and be prepared. And when you go into the police that day, are there any prior history? Why, yes, in fact, there are, and here they are. Let me tell you all about them. And you have it written down.
Mm-hmm.
So I think that's important.
And take screenshots.
Yeah, screenshots and send them to somebody else, because if they break into your email, at least it will be saved by another friend, somebody you trust.
Mm-hmm.
And just related to that too, if we're safety planning, change passwords,
Everything.
change passcodes so that email, phone ends up being safe,
Good advice.
a little safer.
You can go take money out of your joint account too.
Mm-hmm.
Money can always be refunded. If you know that if you don't take it, they're going to take it, go take the money out so you have some money to live on.
We tell them that all the time.
Take it out. Money can always be replaced. Your safety cannot.
How long does a temporary restraining order last?
The court rules usually require to bring the matter before the court within 3 to 4 days. It never happens. Our court system is so backed up, it doesn't happen that way. I would think realistically, at least 2 weeks, maybe a month.
A month, yeah. Well, you'll go into court on your return date. At the bottom of your TRO will be a date that you need to go to court.
Just a quick note from the future. William, also known as Billy, had to actually run to court in the middle of this episode, so Alexis, Maria, and I continued our discussion after he left.
When you get your TRO, it'll be a piece of paper, right? And at usually one of the last pages, it'll say what day you have to go back to court. You have to go, all right? You can go try and get a lawyer in between, or you show up without a lawyer. It's okay, all right? You go in, and when you get into court on that day, the courtroom will be packed. Now, they will keep all of the defendants in a separate area of the courthouse. You do not have to worry about, you know, unless you're walking into the courthouse at the same time. If you do see the defendant, don't go, you stand back, right? But, you know, the defendants will be taken into another area. The plaintiffs will be brought usually directly into the courtroom. And then they typically have the defendants, when they bring them all in at once, sit in the front so that they can't see you. They can't look at you. So the plaintiffs are usually in the back area of the courtroom and the defendants are in the front. And the courtroom will be packed. It will be everybody who got a TRO over the past week will be there in Morris County, okay, or whatever county you're in. And the judge will call case one by one, and you'll stand up and say, I'm ready. I want to proceed. If you're ready, and you might not be ready. So if you're not ready yet, you say to the judge, I need more time. I'm not ready to proceed today. I'd like to go see if I could get a lawyer or reach out to JBWS and see if they can assist me. And the judge will not force you to start the trial that day. In fact, the judge will be happy you don't want to start the trial that day. And they'll schedule you probably for 1 or 2 weeks out. You can come back again those 1 or 2 weeks out and say, I'm still not ready, right? And so in other words, I'm not saying play a game with it, but if you're really not ready, right? Maybe you're waiting for a police report to come in. You're entitled to a police report. You go down to the police station, you say, I need my police report. I need to show it to the judge at my trial and show what it says here. I want the body cam footage from the police. People don't know you can ask for that. You get that footage because the police are interviewing. That's what we do when we get retained. We send a subpoena to the police. We say, give us all your body cam footage, give us all of your police reports, and we watch it, hours of it sometimes, and you might catch the defendant in that body cam footage admitting to doing something that you can then present in court as part of your case to get your restraining order. So collection of discovery is necessary, and having all of the documents and proofs that you need, and you might and probably don't, because the police report and the body cam footage are usually not even ready 3 days after you had they don't have it ready. You say I need to get the police officer to come in and testify. They could be a witness in your case. So you send them a letter and you say, I need you to come and testify on this day, and they have to come into court, but they're not available today, judge. And the longer that until that final restraining order hearing occurs, that TRO stays in place, so your protections stay in place. And it's typically a really nice, peaceful time for the victim where they're like, they can't contact me, and if they do, I think this is important. If there is a violation of the TRO, the temporary restraining order, before you get before a judge for a hearing, you pick up the phone and you call the police. The police will arrest the defendant and charge them with contempt of the TRO, which actually is another predicate act.
There are times where we see it as a violation, but the prosecutor's office doesn't.
Right, I agree. They'll still check it off.
But they'll at least check it off. So like, oh, they called, but there was no voicemail left. How do you know it was that person? I've seen that people do go and say, okay, well, they violated and they're going to get arrested. And then there's this like letdown where the AP may go.
And also, they're not allowed to have third parties contact the victim. And I think I know that everybody tries to do it like idiots, right? They'll have their mother or their sister or their brother call the victim and say, can you just drop it? And he promises he'll do X, Y, and Z if you do. Okay. Now, if it's a phone call, you don't really have proof of what they said unless you're recording that phone call. And then you show the recording to the police. If it's a text message and it says, Joey told me to call you and ask you if you would drop the restraining order against him, that go to the police and they could accept that, right? But, or they could accept that as a violation, but it technically is because they're having somebody else contact you. And people do this all the time.
The last thing I'll ask, is there any questions people usually have about a restraining order that or a fear or something that comes up that you would want to just like have them know?
One question we often get, because there is fear that if they don't get the restraining order, will the defendant know that? And if they do apply for a restraining order and they don't get it, the defendant will not know.
Oh, interesting. Really?
The only way the defendant knows is if they get it and then they are served.
So once they get a restraining order, though, the defendant obviously is informed of that.
Yeah, they're served. I will say, if the defendant, though, goes to the police station where the person tried to get the TRO and requests records, any records relating to them, they might be able to get the police records of the attempt of the report, because it would be filed as a report. So, but no, they're not going to be served with anything. They would have to go actively out and seek it.
So that's interesting because when we have a partnership with the sheriff's department, so some folks do come up to the Family Justice Center to apply for their restraining order. So they wouldn't know because they would have to come get it through the.
If they come to the court, correct. I agree. But if they go to the police,
that's interesting. I didn't realize that.
They do the report.
I think this was really a helpful conversation. And as someone who knows very little about restraining orders, thank you for breaking it down. I feel like you made it very digestible. Thank you, Alexis, Billy, and Maria, for such an amazing conversation about restraining orders. I personally learned a lot about this topic that I really didn't know that much about, and I really think the tips you offered will be extremely helpful for people experiencing abuse and getting ready to file a restraining order. If you've listened to this episode and realized you'd like some more information about domestic violence, please visit jbws.org/resources. We're always available to help people in need. One final note, Unsilenced will be taking a break for the summer and returning at the end of August with season 2. So be sure to tune back in at the end of the summer. Thank you for listening to this episode of Unsilenced, Real Conversations About Abuse. This podcast is produced by JBWS, a domestic violence agency serving Morris County, New Jersey. Please let us know what topics you would like covered on this podcast by sending an email to podcast@jbws.org. Please note that this email address is only intended for content relating to the podcast. It is not meant to offer immediate assistance or access to services. If you live or work in Morris County and think you might be in an unhealthy relationship, JBWS is here to help. Please visit our website at jbws.org to learn more about our services, or call our 24-hour helpline to speak to members of our staff at 1-877-782-2873. If you recognize controlling or abusive behaviors in yourself, JBWS can also help change those behaviors. Through our Jersey Center for Nonviolence, JBWS offers programs for men, women, and adolescent males who have used abusive or controlling behaviors in their relationships. Please visit jbws.org/JCNV or call 973-539-7801 to learn more. If you don't live in Morris County, please call the National Domestic Violence Hotline at 1-800-799-7233. Domestic violence grows in silence, so thank you so much for listening and helping us break through that silence through these types of conversations. Please follow us on social media and continue to share our content to get as many people talking about domestic abuse as possible,